Welcome to today's edition of PSLabor Talk. Today I'm joined by Ricardo Torres, President and CEO of Permanent Solutions Labor Consultants. I'm also joined by Cliff Hammond and Jonathan Schwartz of Foster Swift, working here in the Detroit metro area. Today we're going to talk about joint employers. We're going to talk about some of the mistakes that we've seen employers make, and more importantly, how employers can protect themselves. Because let's face it, employers have in the past and do today and will in the future use temporary workers, temp services, contractors, and all of this does have a level of risk involved. But there are ways to protect yourselves, and that is our aim and focus today. My name is Bob Carroll. I'm your host of today's episode of PS Labor Talk. Today we're going to talk about joint employers, and Cliff, I want to start with you, and I do want to go over the history of joint employers with the NLRB, because a lot has changed in the last 10 or 15 years, and it seems like it's changing with every president we get. Give us your take on that.
Well, we had since the early 80s, we had a pretty set in stone standard of what was a joint employer, and everybody liked it to a certain extent because you understood that if you employed somebody but didn't have direct, immediate control of your employee, so you had a contractor or a temp agency, you could say that company is not my jointly employed person, and therefore you didn't have an obligation to negotiate, you didn't have obligations to go in and give information to the union or respond, because that was their problem. If they were to get unionized as a joint or contractor, or if they were to get unionized as a temp agency, that's something they could deal with. And if they couldn't meet the rates when the contract came up, so be it. That all changed under the Obama board. They had a different view, and they looked at what they call the fissured workplace. They said, we really do not like the way you have these employers exerting all the power in negotiations, keeping wages down low, and using the vehicle of a contractor or joint employer or contracted out services to somehow manipulate how the labor costs were going to be, because when a union would go in and negotiate with those individuals, they would say, hey, look, I don't have the money. I literally don't have the money. And the union wouldn't have the ability to force them to give more money back to them. So what happens is, in the Browning-Ferris case, and we've talked about this before, the Browning-Ferris case did a very significant analysis of what they thought the problem was. They said, here's the issue. There is a completely different workforce today than there was in the 80s. In the 1980s, we had very little temp agency and contracted out workforces compared to today. It's just exponentially exploded. So we're going to change the look, and we're not just going to look at whether you have a direct and immediate control of the employees. We're just going to say, do you have an indirect control, which is a really wide look at what is and is not an employer. So the question now is, who's the boss? And if you are an employer who says, we have the right to take somebody off the job, that says, we want certain types of qualities in our employees, we expect them to come to work in these time periods, we're going to control the amount of work you do, then that person then all of a sudden becomes jointly employed for liability purposes under the NLRA.
But how do you not do those things, Cliff? I mean, in fact, isn't it true that a lot of employers would intentionally get contract employees out just to keep them away from the union, or just to keep the union away from them? In fact, I recall back when I was an organizing director, where some companies had subsidiaries to where they were employment agencies, which they would exclusively hire their employees and have that separation, to where if a union got in there, it would make it much more complicated for them to organize the facility.
I think that's the goal. I mean, the whole purpose of having the workplace as we have it now is in order to have a certain level of economic success. What companies have found out is if you have a portion of your company be temp services or outside contracted, you save a lot of money. It's not just in the wages component, it's that you don't have to pay for all the oversight. You don't have to have the administrative burden. You don't have to do the HR component. You don't have to pay the workers' comp.
All the benefits, all the benefits, which adds up to a lot of money. It's very costly.
Right, and part of the goal has been an employer will hire a group of people through an agency, and they can watch those people grow and say, I like those guys, I don't like those guys, but they don't have to pay that added cost for those people. They pay a flat fee to come in the door, and after they're successful, they bring them in, and if they're not, then they say
And
whatever.
it complicates everything, because what company is gonna allow another company or contract workers to come in and not overlook what the quality of work that they do?
Right.
I mean, they have to say, we need you between this time and that time, these days, this is what we need you to do. Without that, I mean, how do you have somebody coming in and working in your facility, and you can't tell them what they need to do?
Well, really, it's an attack on what has been a really successful economic model. If you think about it for a second, the franchise model, it's exactly what it is. You have a company, it lets somebody who's a small business owner come in, buy the ability to do that successful business, then they hire their own people. Well, this says, well, wait a minute. If you're telling them, for instance, let's say McDonald's, who's one of the people that was a target and still continues to be a target of the NLRB, if you go out there and you use a software mechanism or a program tells you how many people to bring on and take off, they're saying, well, that type of force that you put on their labor, you become part and parcel of any type of action they use. So if that employer then goes out there and commits an unfair labor practice by not hiring somebody who's a union person or complains in social media about their company and they say it's protected, you could be on the hook. And the reason why they want that is because they want to say, we want deeper pockets to pay the penalties of these constant long-term problems. Same thing goes to a franchise as it goes to a subcontractor. If I'm a construction company, I subcontract, you're getting rid of jobs that could otherwise have been part of this union structure.
And that's how business has been going on for years and years, decades. In fact, that's the whole basis of the franchise system, is to let people buy into a business. I mean, they're buying into a business, and then they're hiring their own people. This could upend all of that.
And it's not just franchises, it's manufacturing. Look how
Sure.
many different companies are actually working in some of these big manufacturing companies. And when you throw joint employer into that mix, it creates a lot of havoc.
You look at
Well-
Lead Point. Lead Point was the company that was in the Browning-Ferris case. This wasn't some small, operation. This was an operation for recycling. And you had people that were coming in from a different company. They were working there with a on-site manager from their company. They had their own rules, their own set of procedures. There was a hiring contract for them to come in and perform these services, but the individuals that were performing the services might have been side by side with Browning-Ferris's own people, but they had their own rules, their own management system, and they said, you know what, even that system isn't good enough. So no matter how sophisticated people have tried to be to set up their corporate structure, the attack is on that structure. And they're saying you can still do that, but when something goes bad, if you're going to reap the economic reward, then you've got to pay the economic consequences for the mistakes.
Well, I think you talked about, general contractors. I mean, now you're talking about construction projects.
Mhm.
How much could this potentially up the cost of infrastructure work and everything else? Because you have the general contractor who brings in the subcontractors to do the work. The general contractor doesn't really do anything but hire the subcontractors. Now, is that going to be a joint employer? I mean, and at what cost?
Part of what we're seeing now is that the law being so vague and uncertain, there's a pushback that's bipartisan now. So earlier this month, there was a bipartisan bill, the Save Local Business Act, which tried to put some more meat on the bone so people aren't guessing. And so we're not going backwards in terms of, what employers can rely on and what everybody can understand going forward.
Yeah, I think that what you're seeing now is the Save Local Business Act, which Jonathan's talking about here, could be something that a lot of people can get behind, whether you're whatever side of the aisle you're on, because they notice what we're talking about here is there has to be a common sense principle for a small business owner to say, okay, am I going to be on the hook or am I not going to be on the hook for these people who I'm hiring at an arm's length distance in a business contract? Because I might not want to hire people if I know I'm going to be on the hook and not have control.
Yeah.
On the other hand, if I'm not going to be on the hook and it's going to save me money, then I want to do it. It just makes good business sense.
Sure it does, but right now that's all up in the air.
That's right.
I mean, there's nothing set in stone right now. And how do you bid on a project? How do you go into a contract not knowing what the cost could be to you?
And that's exactly the point that we've seen now in the Browning-Ferris decision was a major issue in the dissent by the now chairman of the board, who's in the minority, the Republican minority, because now the board is 2 Democrats and 1 Republican. Actually, we just had this month, it's now 2-2 with another Republican that just came in, Marvin Kaplan, but there's not enough votes to change that, the decision. And what happened in the dissent is they said, look, you're going to get to a situation, you're not going to know who your employer is. You could have somebody who contracts out work with one company and then contracts out with another company under a very similar agreement, and there may be just enough nexus. So now all of a sudden, because one was a joint employer of the other, now the person who doesn't even know the first person you contracted with, now they're roped into this entire process. So what happens? Now can we have unions come out and picket the third party's web? They have absolutely no connection, but they could have a picket on their site. They could have a problem with, a subpoena for information request from all these employers saying, look, because you're jointly employed, we want to know what your numbers are. We want to know who you do business with. We want to have relevant information for bargaining with the one company we have a contract with, even though that person is now 2 steps removed. And then in the future, when you contract with somebody else, how do you contract with that person? Because they don't know whether they're going to be looped into this whole process.
Well, that's a nightmare for you too. I mean, from a legal perspective.
Sure.
I mean, you have to go in a real small amount of time, present the board with a list of employees that you believe are eligible to vote. And if you have multiple employers and you don't know if they're joint employer or not joint employer, I mean, you want that done before that petition's filed, right?
It's like a 2-step process now. When you look at the way that the joint employer doctrines come down, the first thing you have is who has to come to the table for bargaining purposes? This is the first question that was addressed in Browning Ferry. So you have a dispute between Company A and the union. Now that small company, that Company A, the contractor, has a union agreement. But the person who contracted, the bigger company, doesn't have a relationship with the union. Now they're saying that the union can pull the big company in for negotiations. Now the next step's going to be, let's just say all of a sudden there is no union anywhere, but the union goes in for the small contractor and they want to organize them. The question then is, okay, and we also want to have an election with the employees of the larger company. Now the next issue is, do you get an election with everybody thrown in together? Both the employees of the main company and the employees of the temp company. And I've had elections before. If the temps were included with an election with the regular, rank and file people, well, the temps have more grievances because they're probably newer, less wages, less benefits. They're going to probably have a reason to vote for a union, whereas the long-term guys who are happy with the company, been there for a long time, they're happy, they don't want it. But you put the numbers of this temp company in with, maybe there are some people who either, one, don't like the supervisor or have problems with their wages, it might have a problem, and you are looking at the future, if you don't change this, of where we're going to be.
We had a big one. We had a really big one in a Tier 1 automotive campaign here in Michigan.
Mm-hmm.
And those temps, they were talking to the union.
Sure.
And those temps, most of them had 90 days. If they didn't make it, they were done, right? They had nothing to lose.
And temps are going to vote for the union. They're going to vote for the union because it's going to be nothing but a plus for them. But now we're talking about third-party picketing also.
Right.
So where's it at? And that's where the confusion comes in. Now it throws the whole NRA up into the air also, because now the unions might have more rights as far as third-party picketing and other actions.
Right.
Also.
Yeah, so you've got this entire layered issue that you've got going on now. Who's your boss, number one? Who's going to pay the penalty if there's a problem? So if a supervisor in a unionized situation where the contractor does something wrong, do you now have to pay for that contracted out person's mistake? Secondly, do you get drug into negotiations? Third, do you now have a potential obligation to have a vote with it? So it all goes down to the bottom line of who's making these decisions. And right now, the joint employer rule that came out that everybody was a little bit upset about is on appeal. It's going up to the Court of Appeals. That same Court of Appeals, however, just this month in August, came out with a decision that struck down a very similar issue with CNN. They had these joint employees, and what ended up happening was the NLRB went under, they took a look at the old standard that was in place, and they said, we're going to move now to say that, that was not an appropriate standard, but they didn't explain why. And this came out right around the time that the Browning-Ferris came, and they changed their mind on how they were going to apply it, and they did just what we were talking about, which is they just said, look, let's look at economic realities. And if there's an economic reality that you're probably jointly employed with and you have enough control, then we're just going to go ahead and find you guilty. What the Court of Appeals said in D.C. is, no, You can't just simply say we don't like it and ignore all the reasons why there have been. You can change your mind. You can have a new standard, but you can't just do it because you want to. But they noted, we're going to send this back for deliberation under the old rule, or to announce, like Browning Ferris did, here's what the old rule was, here's why we're going to change it, and here's what it's going to be now. So even though CNN didn't lose on that issue in that case, it still says the NLRB is going to get that decision. Currently, the NLRB is at a 2-2 deadlock, so when it goes back down, that's going to be it. On the other hand, NLRB's decision in Browning Ferris is the standard now. It's on appeal. We don't know if it's going to be decided, today or tomorrow in the next couple months, but it will be decided. And if they approve it, then it goes back to the NLRB, who can continue to approve it. And right now, the numbers don't look good for changes. And the reason why that is, you're going to have a 2-2 Democrat versus Republican majority. The two Democrats are on board with the now more lenient standard to make everybody join employers. In December, the current board chair, Ms. Camara, will drop out. He is not going to go for another term. We have the brand new appointee who will be there. So for the time being, it will still be a 2-1 Democrat majority. Now, there is another nominee that's up there for another position that Trump has nominated, and it's William Emanuel. He's an attorney. He's been a long-term attorney on behalf of businesses. He's been actually benched for a while. They're not taking a vote. So if he doesn't get voted in and that doesn't get done, you're going to look like we've been for the last several years, almost for a decade, quite frankly. It's going to be a democratically controlled board, which is more in line with trying to get employee rights as opposed to company rights. So we're not looking in the future to see much change unless an act.
I mean, with all the problems in Washington D.C. right now, I mean, things aren't moving fast. Things are moving very slow. Trump's appointees and everything happening in Washington D.C. is just come to almost a standstill.
Mm-hmm.
So there's not a lot of hope for that to happen real quick.
Right. And again, if the Save Local Business Act goes into place, it would resolve the situation, because that's a statute that could change it, to what Jonathan was talking about earlier. Having said all that, there are some things you can do in your handbooks, I think, for liability's sake, like we talked about, I think, many times, Jonathan.
Sure. So when we're dealing with this uncertainty, there are practical steps that you can take, and a lot of them are drafting your initial agreements from the beginning to try to avoid some of these problems. And there's several provisions in your agreements that you can put in that I'm happy to talk about, which, while we don't know for sure is going to avoid a problem, will go a long way towards helping if something arises, to try to mitigate any kind of problems, or at least give you the opportunity to point to it and say, we are not an actual employer. So the first...
And at least it's going to put you in a better position.
Correct. Yeah, absolutely. And the first of those steps is to talk to your attorney from the outset and throughout. As Cliff has been talking about, this is a constantly changing and evolving area of law, but we stay up to date on it, and our guess is as good as anybody else's. So talk to your attorney. We also know how to draft the agreements to avoid some of these problems. So let's say you're a company and you are getting temp workers to build your products, and you have an agreement with your temp company. The first thing you want to do is specifically state in there who the employer of these temp workers is, and state that the agreement does not create an employment or joint employer relationship. Be as clear as you can that your company is not the employer of these employees.
So actually state it.
State it. It should be one of the first things you put in there. When we talk about an employment agreement, generally we put that somebody is an at-will employee, so you can terminate them. It's right at the top. We suggest the same kind of thing here.
Yeah, so they can't come back later on and say, well, we didn't know, or we thought we were, clearly mark it.
Sure, and there's two things at play here. One is what the actual agreement says, and what is happening in practice. So while you can draft the agreements in a way that's most advantageous for you, we also recommend getting an attorney involved to look at what's actually going on.
Well, yeah, because and I understand that. In fact, if you have hiring an employment agent to come out, And if in fact the practices that you have inside the facility, day-to-day practices, do make you vulnerable for being a joint employer, then all that language goes out the window.
Sure, if you have a contract that says you're not the employer of a temp worker and you have the right to fire them and you're controlling everything they do and there's no oversight by the actual employer, then the court or the NLRB is going to look at that and say, well, it's great that you have that in writing. Let's talk about what's actually happening.
Right. It makes sense.
But you can make a recommendation, and then the smart move is to be in constant communication with the temp company that you have. If there's a problem employee, defer the problem to the agency, clearly state your position on the problem that you have, and let them handle it under their handbook.
And make sure that you have a company, if it is, for instance, a employment agency, make sure that they have their own supervisors on the ground also, so that they can do any discipline on the ground within their own system.
I can't tell you how many companies we've been in that had temp companies, and they shy away from having those supervisors in their buildings.
For cost.
For cost only, but it ends up costing them way more.
Way more, yeah.
Absolutely. Well, and there's an important concept here. So if you're bringing in temp workers, you can exercise some quality control. So what you can't do is say, this employee is bad, I'm going to terminate them. What you can say is, what they're supposed to be making doesn't conform to our standards, and basically send it back. Although we're still kind of walking a fine line between exercising control over employees and exercising control over the quality of the products.
Yeah, I think one of the things that the board brought up, and we're going to see how this goes, is they're not saying per se, but a cost plus contract could get you in a situation where you are a joint employer, potentially. So there are these fine lines you got to look at on every situation. When you're making a business decision, ultimately, look, there's a risk reward for everything, right? You've got to be able to get your product out. You got to hit certain quality standards, and I think you need to be able to put those together. The standard the board has put out there is very difficult to avoid.
And what you just said was the basics of doing business. You
Right.
have to have a quality standard, or you cannot continue to operate.
But what the board has said is, we really don't care about your product. What we care about, because our law says that we're here to enforce an act.
Right.
And that the act is said this way. If you don't like that, go change it with legislative history. We're not worried. And that's not not abnormal for any agency. A lot of agencies, they basically have the tunnel vision of, this is my job. And I don't really care about how your business functions as much as I do the realities of an economic test. And they're looking at the law, and this is how they're going to apply it.
We definitely recommend putting the words quality control in the actual agreement. In certain courts, like the Southern District of New York, in a case Grenwald versus AT&T Mobility, they stated that measures to ensure quality control do not prove control over the conditions of employment. Another recommendation we would give when drafting the agreements from the outset is to describe the rights and duties of the parties in the terms that mirror the tests for joint employment as we know it. So we want to try to shy away from any kind of indication that there is even an indirect control over these employees. And we can put that in the actual agreements from the outset.
Sure, and I think it's very important to keep in mind that there are a lot of different types of liabilities employers can run into. You can run into liability for the acts of an employee toward other ones, so harassment, for instance, being injured on the job. And then, of course, there's obviously the union. Now, each one of these might be covered by one or all at the same time. And even if you are okay as far as avoiding joint employer liability in some respects, so you don't have to pay overtime, you don't have to pay workers' comp, you don't have to pay for an injury, you still may be found under the NLRA, and that's what I was talking about earlier, was the NLRA's decision is unique in that it really went very far, very quickly in changing the analysis. But you can do a lot of different things to try to avoid joint employer liability. At least keep it there, because one good thing about the NLRA is there isn't this significant level of damages that you're going to have to pay for pain and suffering and emotionals that you can for other types of violations of the law if you're found to be a joint employer.
Right, making them whole. Now, but how does that affect the joint employer if you have something like physical or sexual harassment on the job? from the temp worker.
Well, I can tell you historically, the NLRA is moving toward what has historically been going on in that area. I mean, it's very difficult to avoid joint employer relationships if you have a temp employee and there's sexual harassment and you're involved. You're going to be brought into the lawsuit. And there's a number of legal analysis that we can go through, but I can tell you that it's difficult to avoid that unless you've done what Jonathan has said. And that is, you have to go through and you have to analyze what's really going on, how your policies are. And I would tell you one of the most important things you need to do is, to the extent that you want to try to get insurance against, the problems of your contracted out employees, get indemnification language in those agreements to say, in the event that you do something, you're going to pay our bills, our costs, to the extent we can by law. I mean, that's something that you can always try to do as well.
And that's an interesting point. There was a case, the EEOC versus Skanks USA Building, Inc., and there the plaintiff was employed by a subcontractor and ended up suing the employer as well as the place he was stationed at for racial discrimination on a joint employment theory. And while the agreement said very clearly that the employer was not the company that was using the worker, in practice, that subcontractor provided very minimal oversight, failed to properly instruct the employee, and as a result, they were both hit.
And it happens all the time. I'm telling you, the liability's sake, if you just hire a temp, bring them in, work them rank and file, but you have payroll processing essentially from the other company, you're going to be in a very difficult situation as far as the legal construct of harassment or discrimination. What really needs to happen is, if you want to avoid liability, you've got to structure your agreement.
Now, but tell me, in your opinion, how many companies do you think have changed to protect themselves more?
Some
Or
have.
just doing it the way that they've always been doing it?
The ones that have been sophisticated in the past, the ones that have tried to get ahead of this in the past, are trying to do it now. I mean, the whole reason why they're doing it is to avoid these types of liability components. But the ones who continue to work under the old, I mean, there were changes. There's been a dramatic shift in liability for these other non-NLRA cases for years. Those companies who just continue to just hire a temp company, hire out a contractor, they've been hit. And what's going on is, now the Trump administration has actually retracted a couple opinion letters. But what was going on was, just at the end of the Obama administration, there were two opinions that came out that essentially said, look, essentially, we're going to assume everybody's joint employers, okay? And they had two different tests. One was called horizontal and one was called vertical. The horizontal means I set up several companies and I have a person works one place for a couple hours one day, another day they work at another place, but there's some kind of relationship behind the scenes. And they were saying, look, if we can find a way, we're going to find out that you add those hours up, even though they're different companies, if they're related in economic or management or some sort, we're going to tie them together as a joint employer, and you're going to be hit with a Fair Labor Standards Act overtime case.
Well, yeah, I mean, especially if they're going from one facility to another, and there's a upper echelon's control over what happens. Yeah, absolutely, they're going to be vulnerable. But I think in our case, Bob, we've seen a lot of situations to where, and the more sophisticated companies, yeah, they're going to change their practices and they're going to get the legal advice that you were talking about, Jonathan. But I think that that's a minority. I think there's a lot of companies that are continuing on in business as usual.
And that's exactly why when I came to you, Rick, to talk about doing this particular podcast, in PSLabor Talk, we usually talk about union-free strategies, but this goes way beyond just being union-free. There's a whole lot of facets that companies could use to improve themselves, not just from staying away from unions, but to protect themselves from many other issues. I mean, from a union-free aspect or from a union aspect, what fascinates me is some of these buildings that we've been in where they never even considered that it would be a cost-saving measure to talk to attorneys, to talk to people like us, to put processes in place to protect them, really never stopped to consider. I mean, some of these buildings have had 5, 6, 7 different temp companies or more on bigger companies in their buildings. And can you imagine the negotiations process with that many entities involved?
Just to put another level into it, I mean, there have been recent decisions that have come out of other circuits, and what they're trying to do is expand what they call the cat's paw theory, which basically means there used to be a theory that if a manager discriminated against somebody, that if later on that person had an adverse employment, action, such as they got fired or demoted or whatever it was, as long as the decision maker who made that call did it independent of that harassing person, you'd be fine. But now they're trying to go to a theory of, well, look, if that person that's high above made their decision, but they relied on whatever the discipline was or the negative treatment that was given by the harassing person, now they're liable. Now, what comes about this if you're a joint employer? Let's say you have an on-site person, an on-site manager from a temp company who's acting in an inappropriate way, a discriminatory way toward one of the employees because of race or gender or age or whatever it might be, and next thing you know, that person gets let go or the contract's terminated. That's the next level thinking you have to have. How do you set up a system to insulate yourself, whether it be through your work rules, your handbook, your decision-making processes? So how do you do that? Well, we can talk you through that if you get in charge of how you're supposed to go through that decision-making process. How do you insulate yourself to the best of your ability from being hit with a liability suit? So those are big concerns.
Yeah, and I think they call it strategic planning. Where you have to look at the possibilities as you move forward. And once again, I mean, it's really an important topic because I just think that this, especially with the confusion with all the changes that have been going over, happening within the last couple of years, and it can make your head spin. I mean, we talk about it all the time, but this is what we do.
Right.
But there's a lot of people who don't have time or who don't have the patience or, they just don't have the knowledge to think this out and say, okay, well, we need to put a strategic plan in place so we can protect ourselves moving forward. And I think there's a lot of need for this conversation right now because I think there's a lot of companies that have to look at where they're going to put their resources moving forward.
One more tip that I think is really important, and there's dozens of contractual provisions that we can recommend that are added to the contract at the outset. While this law is very amorphous and changing and we don't know where it's going, you can't necessarily contract away liability under the joint employer theory, but what you can do is add an indemnification provision. So if you get hit, then you have somebody to point the finger at least to try to get money back.
Yeah, Jonathan, why don't you explain that a little bit more for people who may not understand exactly what you're talking about?
Sure. An indemnification provision basically says that if you are sued, then the other party to the contract agrees to pay whatever damages that you are responsible for. You can do things like adding that they will pay your attorney fees, they will take over representation of you, or if there's a judgment or any fines imposed against you, then they are responsible for reimbursing you for that or paying for them.
Well, that also goes into the point of when you're making the decision of who to contract with, a lot of times what employers want to do is, if you're a small employer especially, you get an individual, they're a good hard worker, but you're like, I really don't have the money to bring them on as a full-time person, pay them overtime, do all these things. And in a non-union setting, we're just talking about a small employer trying to grow, sometimes they'll hire them as an independent contractor. You can have all the great flowery language you want. The problem's going to be if that person does something wrong or you get hit for that liability, are they big enough to pay you?
Are they big enough to pay you? Exactly. And how many employers is that going to scare off? And how is this going to affect? Maybe it's just cheaper for me to hire my own employees and just work the heck out of them. Is that going to change also?
Yeah, what about all these employers that we've seen? And this has become a big problem even when we're dealing with these groups and a union campaign at the same time. And they have temp to hire programs. It's very common.
Sure.
But their idea of temp to hire is, well, let's get a body in the door. Literally, they'll call them a body, not a person. Big mistake, right?
Mm-hmm.
They bring this person in the door. On paper, 90 days they work out. Maybe they'll get a job or find the right fit for the building and bring somebody else in.
Mm-hmm.
How many people will leave that person in that position for months after that 90 days? Years after that. And it becomes just a sickness within the company. Because other people that have their positions see these people who should never have made it past the 90 days. They have a spot there. They're getting a paycheck. They're doing minimal work. They're not part of the culture. Rick likes to call corporate building the perfect corporate DNA, but they have a destroyed DNA when they leave these people in there. But then you start talking about these joint employers and some of the things that Jonathan's talking about, and you have these type of people in your building. you are literally asking for those problems at that
Well,
point.
and this too, Bob, when you have an employee, and he might be a temp worker, and we've had this happen many times, where they're in a facility for a year, 2 years, in a facility working, and they become part of the environment, with the workers. The other workers who are full-time, who work for the company and not the temp agency, come in and they look at these workers as, their buddy or their friend or their colleague. And now knowing that these temp workers are gonna have issues, they're not gonna be happy because they know that, their job's on the line. And they're making less, and they're not getting the benefits or whatever else is going on. And now they have a grievance with management.
Yeah.
So the other workers are gonna be listening to them. Well, it's wrong for management to do this, and it opens and makes the company more vulnerable for union organizing campaigns also.
So they did build a DNA, it's just not the DNA they originally
Well,
wanted.
yeah, they did, exactly, because, it's all, association has more of an influence than who
Sure.
your boss is. The association that you have day in and day out is gonna influence you more than who your employer is.
Mhm.
And Rick would tell, and he tells me this all the time, when you have that type of environment, the union organizers, and more importantly, the union, the directors of organizing, they salivate over that kind of opportunity.
Well, it's one of the weaknesses in the infrastructure that you look for when you go and talk to workers about, that have called you for organizing. What are the weaknesses? What are the structures that are crumbling? And that's a great example of something that when I was on the other side and I had organizers all over the country and I was directing them, that I would have my organizers look for. This was a weakness that could have a big impact on an organizing drive. That's one of the things that we look for. What are the weaknesses? You always, when I sent organizers into a facility, I said, okay, let's look at the infrastructure, which is the relationship between the frontline supervisors and the employees. Well, when you have a situation like that, it makes the company much more vulnerable and open to organizing campaigns.
And a lot of times it's hard to see that because there's two things that happen. You have a scalability economics to it, right? So I got to get bodies in here, like Bob was saying. I got to get people in here, and I don't have the time to go vet them. I need somebody to bring them in here. It won't cost me as much. I'm going to be able to outsource that cost because I got a big purchase. I got a big job, or we just landed a new contract, but it might only be a year or two, so I don't know how long it's going to be. So that gets you in that trouble.
Well, once again, we talk about strategic thinking. I need something right now, so forget about the issues that we're going to have maybe a year or 2 years down the road. I have a problem I have to solve right now, and it's an easy problem, so I'm going to do this. It's the lowest common denominator. We're going to get somebody in here, and hey, they're working out, so we don't have to take more time bringing in better people or bringing in full-time people or really making sure that these people are up to the standards that we want. So, and the communication, the biggest cost of union organizing campaigns is the breakdown of communications. So if the communications are bad, they're never going to get that feedback.
And there are other risks to businesses from having a temp worker on the premises. Lots of personal injury lawyers know that if an employee is injured on the job, then it falls under workers' comp, at least in Michigan. But if a temp worker is injured at somebody else's facility, they can claim workers' comp from their employer, but they can also bring a third-party claim against the facility. And I've litigated cases like that where arms have been smashed and people have died. This is a big potential risk for a business, and if you're not big enough, it can torpedo you.
Oh yeah, it could be the difference between growing and going out of
And going to
existence.
business, yeah.
Yeah.
Now, the other thing that you see is that people always see a skill set in an individual position. There's a high-level position. Whether you've got a 10-person operation or you got a 1,000-person operation, there might be an IT position. There might be a vice president of something. There might be some person who's a salesperson, whatever it is. And you say, I need this person, I need them quick, and I know this one person, and they say, you know what, I really don't want to come in the office every day, I want to do my own thing, and they say, how about we just make me an independent contractor? Well, that's maybe not a problem that you've got from an NLRA perspective, but from a wage and hour perspective, in terms of payment, that person might not necessarily be a joint employer just because you write a contract called joint employer, because I see it all the time where people everybody's hunky-dory, everybody's happy, they're all glad to see each other until it's not happy, until it ends, and then they say, I know I signed that thing, but you owed me overtime because I really worked hard for 90 hours a week, and you never wrote a time card down. Now you owe me not only that, plus you owe me, damages on top of that, and it becomes very expensive very quickly.
Hey, Bob, how many times have we seen situations to where they're great until they're not?
Mhm.
Well, I was just also gonna ask you, Rick, and you, Cliff, how many times have we been in a union campaign situation and we see something that could be a potential or an obvious ULP, and the client says, but it's in our handbook.
Yeah, right.
It's in our handbook, we're safe. Oh my.
Mhm.
How many times?
Right.
I
Time and
would
time
venture
again.
to say almost every single campaign
Yeah.
that we've worked.
A lot of
It doesn't
campaigns.
matter what's in the handbook, it matters what they actually do on the ground.
Well, right, and this is, Jonathan and Cliff, this is what takes, because a lot of companies, they're not, they're not labor or employment attorneys. So they are going back the notion, and this was my point earlier, they don't have the sophistication, and a lot of employers don't have the sophistication to understand what is legal now under the laws that exist now versus what happened years ago. Or maybe they've been doing it a certain way and they just haven't had a problem, but we know when the problem happens and then it can spread out. So once again, it can cost them a lot of money, but they don't have the sophistication to know the difference because they're not employment attorneys or labor attorneys, and they just, you don't know what you don't know.
And another
Go ahead.
problem is if high-up executives know or an in-house counsel knows, but it doesn't percolate to the people who are supervising the factory. The people who don't know what the agreements actually say, but they are telling people what to do on the ground.
Well, exactly. I mean, the bottom line is if a company wants to stay union-free and stay profitable, the production high, they have to make that part of the corporate DNA. And it all goes down to what is the training, what is the knowledge that is given to the frontline supervisors, and the ability to bring that back up the ladder so that the people are in charge, the executives in charge, have an understanding of exactly what's happening. And in fact, this is the root of almost all the problems that we're talking about, is because we have the communication going between the employees and the frontline supervisors is not going back up.
Right.
And a lot of that's because of ignorance. They just don't know.
Absolutely. Hey guys, we're out of time, but I want to end on this. We have plant rules, right? And then you have company policies for the people that actually own the company. And then there's company policies for the temp workers that are in the building. What order do we follow? Plant rules come first, safety, right? What order do they follow?
I think the most important thing you have to remember is there is no such thing as, what do we follow? If you're an employer and you have employees, then you have a set of rules that have to be followed, period. If you have a temp agency, as Jonathan was talking about it, make sure they're true temps, and then you contract with them so that they are a separate, complete employer. If you retain the ability to remove people who break your company rules, I just hope that anybody listening here understands that might be a great decision that you want to make and you want to stand by. But when you do that, under the current analysis, you just took on potentially the liability of having those people as employees. So you make the decisions. Every decision you make is fine. You make a lot of consequential decisions in everyday practice. That's okay. But what we want you to do as attorneys, we want you to know what the facts are, what the legal obligations are before you make that decision. So if I were going to say anything on that point, I would say make your rules, make everybody who's your employee follow them, determine who is your employee, who is not your employee, and who might be your employee if you want to go ahead and have more rules and more obligations for people who aren't necessarily your employees.
And Jonathan, would you say that actually doing your research when retaining these temp companies and finding the temp company that is most aligned to your mission and your vision is a real important step?
Absolutely. There's a lot of fly-by-night temp agencies. You got to be really careful. But the analysis doesn't just end at, what is this company's rules? Do they have a good reputation? Some of it may be how reasonable are they in negotiating your contract. If they're not going to agree to indemnify you for what their employees do, then you have a big risk there, and you may not want to take it.
it's almost like buying a used car and not taking it to a mechanic, you know.
Mhm.
But and I think the bottom line is when you make these decisions, make them based on knowledge of the law and exactly how it might or could affect you moving forward.
And Rick, in closing with you, based on your union experience, what advice would you give employers that use temp companies based on how you, because I know you've shared this with me, you would use the temp companies to get people in the door to assault the places, right?
Well, yeah, I mean, it's really it's really
was
you
really
know,
easy for you.
101 is a non-brainer. We used to do that all the time. In fact, we used to in some of the larger cities, we knew people on the planning commissions. They would let us know what companies were coming in. It's just like you had the empowerment zone in the Midwest, and we would get on, you know the city planning people. They would let us know who's coming in, who's doing the hiring for those companies. We used to send people in there, and we'd be in on from the get-go.
But it'd be so much easier for you. Look at these southern companies like the BMW and the Nissan. It'd be so much easier to get somebody in working as a janitor for a temp company than somebody on the line making cars.
Absolutely, and in fact, it makes it even easier because a lot of these companies use the temp companies as how they hire their people, the permanent people. So if you make it through the 90-day period and you're doing a good job, we'll review you and then we'll bring you in as an employee. I mean, how many times have we seen that? It makes it so much easier to get a foothold within the company and really tarnish it. I mean, when the company hires people in from the street, they will do an orientation. Well, when we had people in on the ground, there would be an orientation every day to poison their attitude towards the company. So, I think a lot of companies use it so it makes it easier or makes it less expensive on how to get their employees in or how to hire within there. That gives them kind of a certain amount of time where it makes it easier for
They
them to
step
see
over
if
an hour
right.
to pick up that nickel.
Right,
Gotcha.
absolutely, and it's a quick fix to a long-term problem, and it can come back and bite them. And when I was on the other side, this is what we used to look for. We used to look for this because it made it so much easier for us to do our job. And when we went in there, it wasn't a quick fix. We were going to communities, we were going to cities, and we just like when they had the empowerment zone, we would go in there long-term. And it wasn't our objective just to go in there, run in there, and get a company or two. We went in there to implant ourselves within the whole community of new companies that were coming in. So it was so easy to fool a lot of companies. In fact, we had a company in Michigan to where I actually hired a bunch of it was in the Hispanic area of Detroit. I actually hired the ex-farm workers, or their farm workers. I hired them and brought them in, and we were doing a community event to where we were changing the name of a street to Cesar Chavez Avenue. It was going to be / this street / Cesar Chavez Avenue, and we had some of the local politicians who went to these companies because it was a good cause, went to these companies and said, we want you to open up your doors for this petition. And they went in there and they let us, some of the biggest companies that we later on organized, open up the doors, let us in, sign the petitions with their name, their address, their phone numbers, all the information that we could get in their lunchrooms. So, the possibilities are endless. So and I think, Jonathan, you hit it right on. You have to do your research. You have to make sure. You have to be careful. Make sure that the company is reputable and their standards are high. And I think that's the most important thing.
Yeah, so we got to wrap it up. Rick, always glad to have you. Cliff, glad to have you. Jonathan, we're super excited to have you here today. We hope to have you on some more episodes. Thank you, and we'll see you next time on PSLabor Talk.